So a financial power of attorney and a medical power of attorney are nullified once they pass. Yes, if a person has a durable power of attorney, a healthcare surrogate form, which is also a medical power of attorney, or other sort of advanced directives like this dealing with direction regarding their finances or what somebody can or can't do for them legally, or medical wishes if they want somebody to be able to advocate for them, especially if they're unable to themselves or if they're incapacitated. These types of documents, a power of attorney, healthcare surrogate form, they're no longer effective after the person who created the document passes away. I see this most often with durable power of attorney, where somebody who's listed as an agent under the durable power of attorney, that's the person who is able to act on the creator of the form's behalf. So they can do things like banking for that person or sign a legal document. They can potentially add beneficiaries to things of this nature. That ends when the person dies. So I've seen a mad scramble sometimes after somebody dies and they realize, oh crap, there's going to be a probate for a bunch of assets. So let's hurry up and try to put beneficiaries on accounts, or let's try to move money around. Let's try to close down this account or move something out or do things to avoid probate. Though the intention may be good, right? And hey, maybe the agent's doing this for the sake of this person's children or other people, people who they want to be able to receive the decedent's assets without needing to go through a probate. So the intention can be good, but the document itself is no longer valid. So you can't continue to act on behalf of the principal, the person who created the form, after they've passed away. Which brings me to another point. It's a really good idea to get things done in advance of needing them. So I know some durable power of attorneys can be a little bit of a beast to get through. Ours is a 30-page document. It's not a difficult read, but we make it broad intentionally because we want to make sure that we are doing everything we can to prevent the need for a guardianship where somebody has to actually go into the court system to get legal authority to do these things. So, people don't always just sit around and read the documents, but there's several things that if they're not in place already, such as making sure there's PODs on bank accounts payable on death, beneficiaries listed on other accounts, potentially a ladybird indeed for the home if somebody owns a home. If these sort of things aren't in place and the person who owns these assets, they're no longer in a state of mind or physical shape where they can actually make sure that these things do get in place, well, then the agent under the power of attorney should make sure that they happen during the person's lifetime, if that's what they want. Because after the person passes away, you should not be performing acts under the durable power of attorney. It's definitely not worth it if it gets found out that you were in somebody's account or changing things regarding their account after they passed away. All right, so I hope this clarifies the question. And if you have any other questions about documents like advanced directives, estate planning in general, anything to do with asset protection, Medicaid, or probate, and you're in Florida, please don't hesitate to contact our office. We're atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.